This is one of the two big defense myths about asbestos and bankruptcy. Number one, the plaintiffs are double dipping. Number two, there's a lot of money in these bankruptcies. There is one area in which there is, in fact, a potential for double dipping in the sense of it being dishonest. And that is in every trust, there's a provision for extraordinary claims. And these are defined as claims where at least 75% of the exposure is to the asbestos-containing product or conduct of the company for which that trust is responsible. It's a logical conclusion that somebody is unlikely to have 75% of their exposure to more than one company's product. And so one could say, well, maybe this is going on, and there are plaintiffs saying that they qualify under this with 2 or 3 or 10 trusts. In the entire history of the pending trusts, there have been approximately 12 extraordinary claims that have been processed to a conclusion. So if there's double dipping going on out there, there's very little of it. It can't be a real problem. The other issue is, gee, there's lots of money in these bankruptcies. The Bates Group has never disclosed the basis of its numbers, the data it relies on, although we know that they have data from 50 to 100 companies, which has never been produced. But obviously these companies are in bankruptcy because at least most of them had a plausible argument that they couldn't afford to pay what they owed, and therefore every trust pays a fraction of the liquidated values. That's the reality of the money in there, and it's not much. It is, and the proof that it's not much is that in the real world, the defendants don't care about it. Any defendant who wants to go to judgment and pay a judgment has a subrogation right to either get a credit for what the trust has paid or to take over and present that claim as an indirect claim to the trusts. There have been, to date, in all the trusts that are processed through Verus, through Delaware, out of California, not one indirect claim that has been paid. There have only been a handful that have been pursued with any level of seriousness. Now, this is not trivial money, but it's clearly not important to the defendants, because a defendant who goes through trial, who has done the discovery, has proven up a case by laying shares off on others or done reasonable inquiry, has looked at the trust site lists. I mean, these trusts, unlike every defendant, have posted admitted exposure site lists. All a defendant has to do is give the trial paralegal an afternoon to go through the file, pull together the information, fill out some forms online, and submit them. I don't think it's $1,000 worth of time, and not one defendant has ever bothered to really try to collect this in any meaningful way. So if this is so much money, why are they ignoring it? And as an homage, or what my young friends would say, a shout out to our friends in Toledo, the home of Kalo and the heartland of American asbestos manufacturing. I propose for you the corollary: there's no whining in asbestos. So on the subject of bankruptcy, guys, get over it. The update on asbestos bankruptcy is it's the plaintiff's problem. It sucks. Nobody's getting nearly what they deserve. It has no real meaning to the defendants at all, except that it is a very useful tool for them to continue to use to do 3 things. Number 1, poison our jury pools by spreading a lot of nonsense. Number 2, mislead and confuse particularly gullible members of Congress and state legislatures around the country. And third and finally, as I have demonstrated, to subvert God's law. Thank you.